Hello, everyone. Thanks for joining us today. My name is Marche. I'm the webinar director here at Advice Chaser. Before we introduce our guests and get started, I do need to do a bit of legal housekeeping. Advice Chaser, the host of this webinar, is not a registered investment advisor. We cannot and do not give financial advice. Today's presentation is for educational purposes only and cannot be considered advice for any person's individual situation. Advice Chaser regularly hosts informative webinars such as this one, featuring a variety of knowledgeable professionals, many of whom are licensed advisors. Any opinions, ideas, jokes, or principles expressed by presenters are their own, and however true, funny, or interesting, are not endorsed by Advice Chaser. Please do not act on the information you hear today without consulting a qualified financial professional. Well, we're thrilled to bring you this educational presentation. Attendees are muted, but we encourage you to ask questions in the chat box. And the presenters have asked that we hold questions till the end of the presentation, and we will address those during our question and answer section. Oh, let's go ahead and mute if you are one of our panelists, please. If you ask a question in the chat box, and especially if we can't get to it during the presentation, go ahead and leave your phone number as well. We will reach out to you after today's event to make sure we answer your question. We want this experience to be as educational as possible. Please don't hesitate to ask for clarification or expansion of the material. Well, I'd love to introduce you to today's moderator. Alex Polowski is president and founder of Basic Concepts Financial Services, LLC, and has been a licensed professional in the insurance business since 1989. His expertise is in financial planning for both businesses and individuals. He's a registered representative of Hornor, Townsend Kent, a member of FINRA and SIPC. Alex is also securities licensed in the state of Pennsylvania. Along with financial planning, Alex is health and life insurance licensed in Pennsylvania, Ohio, West Virginia, and Virginia. He also works with small to medium-sized companies for medical, dental, vision, voluntary benefits, FSA, HSA, HRA, COBRA, and 401k plans, and self-funding medical, dental, and vision benefits. And Alex, say hello, and I know you're going to introduce our presenters today.
Hi, thanks for everyone joining us today. For some of you, this may be a repeat. Hopefully not all the information is not going to be a repeat because we do have another presenter today. First, I'd like to present Bob, who was with us on our first meeting. A little background on Bob. Bob graduated with honors from the University of Notre Dame in 1975. He earned his MBA at Duquesne University right here in Pittsburgh. He also serves on the executive committee of the Pittsburgh chapter of the Pennsylvania Institute of CPAs and on the Planning Giving Advisory Board of the Catholic Diocese of Pittsburgh. Bob also is a board member and currently secretary of TC House, which is a nonprofit organization which was built for young adults with Down syndrome. He also serves on the board of directors of Gateway Rehabilitation Center, which cares for people with substance abuse and other behavioral health issues. Our second guest is Megan Loftis. We're glad to have Megan to give us some insight on the legal side of special needs planning. Megan is the owner and attorney at Loftis Law Firm. She's been working in the area of estate planning, trusts, special needs planning, and estate administration for the past 10 years. She's had her own practice for the past 3 years, which she acquired from the attorney that she worked for initially prior to that. Her practice covers all the areas in Western Pennsylvania. She also holds 2 bachelor's degrees from Washington and Jefferson College in political science and business administration. And additionally, Megan also pursued her law degree, incidentally, from Duquesne University. She also has involvement with many volunteer organizations in the past, including Special Olympics, the court-appointed Special Advocates for Children. She's also a board member for the Down Syndrome Association of Pittsburgh. She's been helping families with special needs navigate the difficult decisions and planning for their family's future. So I believe Bob is going to head off this meeting, and then he will hand it off to Megan here thereafter. Thanks for joining us today.
Thank you, Alex. Thanks, Marche. I'll dive right in if that's okay. Again, as was said previously, we're here to provide general information on specific advice, but we'll do our best to give you some basic building blocks so that you can ask informed questions when, in fact, you do sit down with an advisor, and we highly encourage you to do that when the time's right. Specifically, we want to talk about providing for quality of care for the special needs person in your life, and what to do when you're no longer there to care for them. A comment that parents often make to me is, my spouse and I will take care of our child as long as we live. It's when we're gone that there's an issue. Who's going to care for our child the way we care for our child, and how do we make that happen? So part of what we want to talk about today is how to make that happen. One of the key issues is that the person with special needs in your family, if they qualify for Medicaid, then all other personal resources can be used to provide for quality of life. If they don't qualify for Medicaid, then those personal resources have to be used to provide for basic food, clothing, and shelter, things that the government might otherwise provide for if you have proper planning in place. And especially if you're no longer here. If you've got a minor child, especially under the age of 18, you may say, well, I work, my spouse works. We don't qualify for any of that. But when your child reaches 18, or if you're no longer here, then they're measured on their assets, and anything you leave them becomes their asset. So there is a proper way to plan for this to allow you to provide for the quality of care that you want them to have for however long they're on the planet. With that, I would say there are two basic parts to this, financial planning and estate legal planning. Megan's going to address some of the legal issues, and then I'll circle back to talk about some of the financial considerations. So with that, Megan, if you'd like.
Thanks, Bob, and thanks, Marche and Alex, for having me here today. I am, as they mentioned, an attorney in Pennsylvania, so I'm going to try to keep the specifics as general as possible, and recommend that if you are outside of Pennsylvania, that some of the situations might be a little bit different based on your state of residence. And the important thing about the legal considerations is, why are we worried about qualifying for benefits? Medicaid is a federal program. However, it is administered by each state individually. So by moving, like I said, with one state to another, the qualifications to have benefits may be different. So in Pennsylvania, the resource limit is no more than $2,000. So that requires some unique and specialized planning, because most people could reach $2,000 very easily if it's left improperly. And special needs estate planning is just a whole different area, as opposed to somebody who just has a regular general estate plan with just your typical will. And what I'm going to be talking about a little bit is what qualifies somebody to have a special needs trust. What are the different types of trusts? So in special needs planning, I mentioned before, there's a $2,000 asset limit. Once you get over that, you are disqualified for what's called SSI. And so then that person can no longer receive a monthly income, and they cannot qualify for medical assistance benefits. So what we want to do is plan for that quality of life afterwards. And the way to do that is through what's called a third-party special needs trust. But I'm going to pivot back for a second here as to what the other types of trusts are, and what the circumstances would be to qualify for those. If somebody does qualify and then say they're injured in an accident and they receive, they're disabled from the accident and they receive benefits, that would be filtered into what's called a first party trust. If a person inherits money in a situation of they're left money by a grandparent, parent, a well-to-do relative, and it's not put aside into a third-party special needs trust, that also becomes a first-party trust issue. And what we mean by a first-party trust is the funds are generated by the disabled individual either being in an accident and becoming disabled, or they're the person inheriting because of the unique issues. Whenever we get into a second type of trust, there's what's called a pooled trust. So sometimes we have people who do inherit some money, and it might not be, tens of thousands and hundreds of thousands of dollars, and they're eligible for what's called a pooled trust. And those are usually managed by organizations such as locally here, we have a place called Achieva, and they manage the pooled funds into a general trust, and those funds can be used for that disabled individual's benefits. And so what happens there is, there's not as much control, but there's still the option to qualify for the Medicaid benefits because it's put into this pooled trust. So those are two of the other types of trusts that could happen. And what the problem with those is they can provide for the disabled beneficiary or the disabled individual, but then they are subject to what's called Medicaid payback rules, meaning that if there aren't any funds left upon that disabled individual's death, the money has to go back to pay all of those benefits they received. So in essence, you can't leave that money to any other individuals. It goes to the state that gave those benefits over the years. So that's why we kind of worry about leaving it improperly, because if there is a substantial sum of money left over, you would want to be able to control that. So on the next slide, Ginny, we're going to talk about will versus a trust. So, I always recommend to clients, everybody should have a will. I don't care if you think you own nothing. A will is so important because it does two things. It provides for who's going to inherit your assets, and it's also going to provide for who's going to be in charge of everything. But in special needs planning, we also have to talk about trust. And the reason being is that any money that you're leaving for a special needs individual, who, whether it's a child or an adult child or any sort of disabled person, has to be set aside in this third-party special needs trust. And a living trust is simply a document that is created during what we call the grantor's lifetime. So in a common situation, I've a set of parents who comes in with a special needs child, and they create a trust together, and they ultimately say to me, this is going to be for the benefit of this child, and then we have certain considerations to go over, such as who's in charge of it, who's funding it, and who are the ultimate beneficiaries upon the disabled child's death. So you can go to the next slide, Ginny. So part of this conversation also comes into play is a guardianship. As most of you probably know, as if you're parents of a special needs child, you have all the legal guardianship up until age 18. Upon they turning age 18, they might not be considered an adult in your eyes, but they are considered an adult for legal purposes. So they might not be able to make their financial and medical decisions, but they are considered legal adults. So what is a guardianship? We commonly have somebody appointed in that will that says they're going to be the guardian if something happens to myself and my spouse at the time of my death and my child's under 18. But with special needs planning, we also have to plan beyond age 18. Some special needs individuals may not be able to live on their own and make their decisions when they're over 18. Some can live their full lives and be able to do that. So a guardianship is something where you're appointing an individual that you would prefer to be in charge of your child and an adult child's decisions in the case of your passing. So a guardianship is important, and you want to make sure that you're picking out somebody that can handle the different medical and financial decisions for your disabled individual. So, so what are some other legal considerations when you're making this plan? I hear a lot of people say to me, well, I'll just leave everything to my other children and they'll take care of their sibling. Or we'll just disinherit them and they'll just be provided for by those Medicaid benefits. Well, those all sound well and good, but what about down the road when the parents are deceased and the siblings disconnect and don't get along, and it becomes too much of an emotional or physical job to be that person in charge of taking care of the disabled individual. So there are a lot better options, and the better options in this situation, as I mentioned in previous, is the third-party special needs trust. And what that means is any individual, whether it's a parent, a grandparent, an aunt, a friend, I mean, anybody that you can think of can set up a trust for the disabled individual. And what happens is the third-party special needs trust is going to provide for that quality of care that Bob mentioned before, meaning that if your disabled individual needs something like additional medical equipment, or they were used to going on a family vacation, they are going to be provided with those additional benefits. And the thing with the third-party benefits is once you name the trust as the beneficiary on certain assets, which Bob will go into later, then there's no limit to what you can fund the trust with. You know, some people want to fund it with they can fund it with a small amount of money, or they can go to a large amount of money. It really depends on the individual family and their circumstances. The second thing is that there's no generally payback provisions that I mentioned before, where you can name the ultimate beneficiaries upon the disabled individual's passing. And that's very important because that money you might have worked really hard for and planned really well for, and you want to make sure it stays within your family. And then the third thing that we always want to talk about is who is the best person to serve as a trustee. When you think of a trust, remember the trustee is the person who's going to be holding the purse strings. They're going to be the person who basically is contacted and told this person needs this money for, you know, a wheelchair endowment, or we need to put in a special piece of medical equipment in the household. They're the person who's going to write out that check, because their job is to make sure that the benefits that that individual needs is not going to disqualify them for Medicaid by paying out for that bill. They're also going to make sure that if there are additional benefits besides Medicaid, there's local state programs that provide supplemental care, which I'm not going to go into. They can also be the knowledgeable person to say, hey, let's try this avenue and maybe we can keep the assets in the special needs trust. And so typically I recommend to clients is what's called a corporate trustee. So a lot of people say to me, corporate trustee, that's a bank, right? Well, it doesn't necessarily have to be a bank. It has to be an organization that qualifies to serve as what we call a fiduciary. They have a level of care where they have to be prudent with the money, and they have to make sure that they're not mishandling the funds. So what a corporate trustee can be, it can be your typical bank. However, I see a lot of banks will not take a trust unless they have $500,000 or more in it. And I see their fees be prohibitive. So there's a lot of usually local organizations that work with special needs families that will serve as a corporate trustee. Then the second part to this component as trustee is having somebody that kind of looks out for the disabled individual. In this case, we call them in Pennsylvania a trust protector. There might be a different word or language for that type of person, but that's typically the family member that you're going to keep involved with the disabled individual, who can kind of look out for them, question the corporate trustee, they receive the accounting, and be general advocate for the disabled individual. So now that I've talked about how a special needs trust is created, who's in charge of it, who can benefit from it, what are the expenses that a special needs trust can pay for? So I mentioned a few of them. They can pay for in-home care. Maybe somebody needs to come be with the individual for a few hours a day. Vacations. The family always went on a vacation. Now that, the parents are gone, who's going to take them on vacation and how is it going to be paid for? What if we need special equipment to travel on a vacation? Items for the household, any medical expenses that are not covered by Medicaid. There's some limitations as far as home purchase, but I'm not going to get too much into that, but that can be used to potentially purchase a home in the name of the trust. And then there's a few other, Jenny, if you want to go to the next one. There's a few other considerations that I'm going to turn over to Bob on the financial side, but the whole concept of the legal side for special needs trust is that whenever you do this, you want to work in tandem with your overall estate plan to make sure that you have the correct funding, the correct legal documents, and you also want to make sure that everybody who's going to be involved with your disabled individual is on the same page. So without further ado, Bob can take over on the financial side of things.
Very good. Thanks, Megan. So as we've said to this point, there are two basic government programs, SSI and Medicaid, at least Medicaid in Pennsylvania, medical assistance and Medicaid. SSI is an income program. It provides a monthly allowance that covers things like food, clothing, and shelter. And Medicaid is health insurance for someone who's potentially otherwise uninsurable. So it's really critically important that that your special needs child qualifies for one or both those programs so that other resources can be used for other things. So how much is enough? How much other money do you need? How long does it have to last? What is it that you're trying to accomplish? Where will it come from? It can come from anywhere. It can come from parents, siblings, grandparents, gifts. If it's from anybody but the child themselves, that would be considered a third-party trust situation. If it's, as to Megan's point, if it's the child's money because the child was the recipient of a medical malpractice suit or inherited money or otherwise, they would create a self-settled or first-party trust. What can go in there? Virtually any asset can. Real estate can. Megan said the home, for example. From my perspective, the problem with the home is, I don't know about your home, but my home doesn't make me money. My home costs me money. You have to pay the rent. You have to pay the mortgage. You have to pay for upkeep, real estate taxes, and so forth. So if you're going to fund a trust with the home, you better fund it with something that can pay the cost of the home too. But real property like rental property, commercial building, that kind of thing can certainly be one of the items that you put in a trust. Investments really of any kind. In this example, it's non-qualified investments, meaning outside of your retirement account. The downside of funding the trust, a trust with assets immediately, is that a trust is a tax-paying entity. So you need to take into account that trusts pay taxes at the top bracket pretty early on. So you don't really want to fund it prematurely. Plus, if you make a gift to the trust that's irrevocable, you can't have that money back during your lifetime. That's a downside. Not to mention market fluctuation is another issue with any investment, obviously, and especially in this case. Retirement funds, same kind of things are involved. You run also into a bit of a problem with required distributions. The rules on that have just recently changed. Ideally, we generally would recommend that you not fund special needs trusts with retirement funds unless you have to. If you have to, then you do it. But there's a tax consequence that you have to take into account, and it could possibly trigger a accountable resource issue if you're not careful. And lastly, life insurance can be a funding vehicle. And the advantage of life insurance typically is that it does what most parents say they want done. That is, what happens when I'm gone? Well, the thing that pays a benefit when you're gone is life insurance. So it's a fairly efficient vehicle for funding a trust. It creates an immediate estate. It's generally income tax-free, inheritance tax-free in Pennsylvania, can be designed to be federally estate tax-free, free of probate again in Pennsylvania, can be dialed into whatever amount you want and can afford, basically, so it can be made to fit any budget. And it does provide a fixed dollar amount, a guaranteed benefit. If you want to earmark a certain number, I want to fund a trust for X, my retirement plan might be worth X minus something or X plus something 10 years from now, but I can dial in a fixed amount using insurance as a funding vehicle. It also gives you the flexibility of saying, well, perhaps my child won't need this trust later on. I simply change beneficiaries in my insurance. When it comes to insurance, what kind works best? Well, the kind that pays the benefit when the benefit is needed is the kind that's best. That can be term, it can be permanent, it can be whole life, universal life, indexed universal life, variable universal life. All those are vehicles that can be used, and sometimes a combination of vehicles can be used. One type that you may not be familiar with is something called survivorship insurance, or second to die. That is one policy on two people. It doesn't pay a benefit till the second death. But again, if we're talking to a married couple raising their child, if the issue arises when both parents are no longer here, that kind of vehicle is very cost effective relative to two individually owned policies and provides a benefit at exactly the time it's called for. How much is enough? Well, that's a difficult question. In this day and age, the good news is individuals with special needs are often living to a, quote, normal life expectancy, whereas 10 or 15 or 20 years ago, some of those same individuals might have had shortened life expectancies. Well, if your 5-year-old may live to be 85, because that would be, quote, normal life expectancy, that's a long time. That's a long time to have funds set aside. So it better be a reasonably good size number. And if you think about it, if you're earning a sustainable rate of return of, say, 4%, for argument's sake, how much money in the bank would you need to throw off $10,000, $20,000, $30,000 a year at 4%? If you do the math, it gets to be a big number pretty quickly. One guide I've used is a study done by the ARC of the United States that says the average family whose special needs child qualifies for government benefits spends on average out of pocket between $6,000 and $16,000 a year. Well, if you're talking about a young child, $16,000 a year for the rest of their life, you're probably looking at about $500,000 to fund a trust to realistically throw off that kind of return, just to give you some perspective. What about ABLE accounts? That's another alternative that can be used, and we hear people talk of. Can I use that as an alternative to a special needs trust? The answer, I would say, is it's more of a complement to a special needs trust. It can do some things a special needs trust doesn't do, but it's got some limitations that a special needs trust, at least a third-party trust, don't have. One is that the funds in an ABLE account are subject to Medicaid payback. Megan alluded to that earlier in talking about a first-party trust. Any dollars that are paid out during your child's lifetime, Medicaid has the right to be paid back at your child's passing. There's also a dollar limit as to how much can go in each year. It's currently $15,000 a year. And there's an overall cap on how much that account can grow to, and that cap is different in every state. It's a fairly large number in Pennsylvania, but what you also need to know is if it gets over $100,000, your child will be disqualified from SSI. And that's true everywhere. So there's some inherent limitations in using an ABLE account. An ABLE account is something that's built on the same chassis as a 529 college savings plan. Same kind of concept. If funds are used to pay for the right kinds of expenses, then there aren't any tax consequences. So that's a good thing. And we find it's a good place, it's a good repository for things like annual birthday
Oh, it looks like, Bob, you went on mute accidentally. You might have accidentally hit your mute. There we go.
I'm sorry, I don't know how much of that was missed, but and again, Enable account is built on the chassis of a 529 and works in similar fashion. There are some inherent limitations to it, but it can be used, and it's one more tool in the toolbox. Another document that isn't a legal document per se, but one that we think is very important is called a letter of intent. A letter of intent is what we would describe as a note to the babysitter as if you're going to the movies and never coming home. Who else knows how to care for your child the way you care for your child? Who else knows that your child won't take their meds unless they're wearing their favorite red sweater, or that there's a particular brand of cereal that they love, or that there are pediatricians that you want your child to see and some that you never, never, never want your child to see? Who else knows that but you? Probably nobody. It's a good idea to write these things down so that the person that you're earmarking to be their caregiver when you're gone knows how to give that care. We have a format that we provide, or an outline that we provide to parents when we're doing the planning, and other organizations have something similar. I know Achieva does, United Cerebral Palsy does. Various organizations provide a letter of intent or a memorandum of intent outline as a starting point for parents. It can be as long or as short as you want, but the more information you provide the next caregiver, the better a job they can do caring for your child. So to kind of sum that up, as Megan said, there's really two pieces to the puzzle here, at least from our standpoint. There are lots of pieces to puzzles when in dealing with special needs, as most parents in this situation know, but specifically in this regard, legal considerations and financial considerations are pretty critical. And it's really important that you deal with folks that are experienced in this arena. Not all attorneys, not all state attorneys even do special needs planning. Certainly not all financial planners are trained to do financial planning. And I can tell you as a CPA, no CPAs are trained to do this. It's just not part of the normal routine in the CPA profession. There are organizations like the Academy of Special Needs Planners, of which I'm a member, that is a national organization that services and supports both financial advisors and attorneys. NALA is an organization that caters particularly to lawyers. Special Needs Alliance is another organization like that. So there are organizations out there, and you can find somebody in your area simply by going to the Academy of Special Needs Planners website, typing in your location, and it'll point you to someone who's qualified, both legal, financial, trust companies that deal in this area where you are. With that, that brings me to the end of my presentation. I don't know if we have some questions.
We do have some
comments,
questions, and I know that Alex has.
Anything like that.
Alex, you'll have to come off of mute, and then Bob, we do have a little bit of a background issue, so if you can go on mute.
I can't hear you.
Okay, I will ask you to mute. Here we go. Alex, go ahead and come off of mute, and then you can go ahead and ask the questions that we've gotten. You'll just have to click on that.
There we go.
There we
You got
go.
me now? Okay.
Yeah.
All right, so let's see where we're starting here. So Bob, how do you know, or Megan, I guess for that matter, how do you know if your child or adult child will qualify for SSI or Medicaid?
All right, Megan or Bob, if you want to unmute yourself, there we go.
So SSI, the actual Social Security program, is based on the income level. So it's not based on work history. So as long as the person, once they turn 18, does not have more assets, like I said, it's $2,000 here in Pennsylvania, since it's the state program, then they would qualify for it. So it's a resource limit here. an income and resource limit. So you would have to, once the child turns 18, is work with your local medical assistance office in your state to qualify them.
Is there any income guidelines on that as well? For the Medicaid?
Yes, yes, and those are all state dependent as well.
Okay. Can anyone contribute to the trust?
For the third party trust, yes, anybody can contribute to the trust once the trust document is set up. Anybody can name the trust as the beneficiary or contribute funds to it. It's only in the first party self-settled trust where that is for the individual with the disabilities funds alone that contribute to it.
Hey, if I don't want to have my child under a guardian conservatorship, are there other options, like say a power of attorney?
So power of attorney is also a state-specific document. I know that as I'm also a notary in my own state, and whenever I have somebody sign a power of attorney, they have to not only be over 18, but they have to have the cognitive ability to know what they're signing. So there are certain people who can just sign a power of attorney, but it's a slim line. You have to make sure. I have some clients that will never be able to sign a power of attorney. So that's when a guardianship would be required.
What about if I move to a different state? Are there qualifications for Medicaid in that other state because of my move?
I'm going to answer that most likely, yes. That's why, unfortunately, it is a federal program, but every state administers it differently. So our income and asset guidelines in one state may differ from another state. So I always recommend, especially if you've done estate planning documents and then you move residencies, that you do follow up with a local, attorney or follow up with your local Social Security or county assistance office.
Okay. Does the trustee do a lot of work to manage the trust, and is it something I can hire someone else to do?
Does the trustee have to do a lot of work?
Yes. To manage the trust, and is there something I can, is it something that you can hire someone else to do?
So typically, the person who sets up the trust is never going to serve as the trustee, because their plan is to have that funded upon their passing. And so you will have either an individual or like I said, a corporate trustee who will be doing the work. So you most likely will be hiring somebody, whether it's a family member or a special like corporate trustee. So yes, you can hire somebody out.
Okay. If things like food and shelter, isn't entirely covered by SSI, how does that gap get covered?
I don't know if you want me to keep taking that, or do you want?
Can you hear me? I'm having difficulty here with the.
Yeah, we can hear you now.
Okay.
Yeah.
Things like an ABLE account can be used for things like food, for example, and to a point, supplemental dietary issues, I believe, can be covered by the Special Needs Trust. There are definitely some trips there you want to be careful of. The idea of a Special Needs Trust is it's meant to pay for all the things that Medicaid and SSI don't pay for, and none of the things they do pay for.
Well, I guess in that case, an SSI would not essentially pay for food. You could use the trust for that. Correct?
The whole concept with SSI is it's a monthly income that you receive, and whether that's used to pay for your weekly grocery bill, or if it's used to pay for rent to stay in the house, that's one thing. But if there are additional needs that because of the disability, that's when the special needs trust could step in and pay that. And the reason I keep mentioning the corporate trustee is they're the person who's going to make that determination. They're going to know the rules of what they can pay for. And if you ask for just something like food or shelter that might not qualify, they're the ones who are going to say, we can't use the trust for that. That has to be with your regular benefits. So,
Right.
If I might,
I guess in this case, the person was asking, how does the gap get covered? But I mean, to give you an example, if my child was, say, on maybe a very high-priced medication that wasn't totally covered, then I would think I'd be able to use that trust to pay for that out-of-pocket expense.
yes.
if they're on a medication that's a prescription medication, I think Medicaid's going to cover that.
Yeah, I just don't know.
There shouldn't be a situation where Medicaid doesn't cover it if it's a prescription medication.
Yeah, well, I don't know if it would cover it. I was just giving an example. I don't know if it's covered entirely. Do they have an out-of-pocket expense? And maybe there's a high-end copay. They could pick it up for that. What about if my child's disabled and working part-time? Can they, provide those? Can they do that occupation and not lose SSI or Medicaid?
Maybe. It depends on their expenditures. So as an example, we often run into this, right? Child's living at home, an adult has a job, you want them to have a job, and it provides them fulfillment and so forth. But it would be perfectly appropriate for the parent to charge that child rent. The rent expense to the child is a legitimate expense. The parent can then turn around and use the money they took in rent and as additional benefits for their own child. So there are ways to accomplish what you're describing.
It says, what if my child won't need SSI and Medicaid and they are able to work, but I would like to set up a special needs trust for them anyway? So is that a possibility?
Yes. Even if your child does not need SSI or Medicaid currently, then you can still set up a trust, because the whole concept is, what if they do eventually need it? Then you've already got the legal document in place and you're not going to disqualify them later on. As long as the qualifying disability was, in this case, before 26 and here, but then obviously we have different considerations if somebody becomes disabled as a result of an accident. That's a different side of things. So yes, you can still set that up.
Okay.
I would say too on that note that if the worst case scenario is, because I get asked this question a lot, the worst case scenario is you spend a few dollars to get the trust established. If it's funded with insurance in particular, you haven't really diverted any assets to it. If your child, it turns out, doesn't need government benefits, disperse the funds. The worst that can happen is they're disqualified from Medicaid. But if they didn't need Medicaid anyway, what's the difference? So I'd rather have it and not need it than not have it and need it.
Right. Bob, I have a 22-year-old autistic son who's being denied Medicaid in Oregon because he has SSI and Medicare, which does not pay for personal care and developmental services. Are there any suggestions?
Again, I would talk to how do I put this? Oftentimes parents find they're being denied Medicaid benefits. A local attorney can help you with that. There is an appeals process. So if they're improperly being denied benefits, you don't necessarily have to take that line down. That's Megan's arena. So that's all I'll say about that. But I would also say that it sounds like a situation where it would make perfect sense to reach out to a local attorney or other support person in your area that knows the rules in Oregon, because they are all different state to state.
Okay.
Yes, I echo Bob's sentiments. Unfortunately, because we are doing a generalized conversation, the state, commonly I work with other attorneys who do regular disability appeals because it is very hard to qualify for it. But in this situation, you would want something that's very, very, somebody local to you who can handle your situation individually, because they're going to know why you're being disqualified and help you the best situation.
And, if my son lived in a special needs village, then SSI Medicaid pays for rent of the apartment. When he lives with me, his check pays for his food, clothes, and maybe $100 towards rent. How can I let him live home and SSI Medicaid pays for his rent? Check pays for food, clothes.
So the concept of SSI is that you qualify at a minimum amount, you get from federal, and then you get a small supplement from your state as well. And that can be used for whatever you choose to use it for.
But it's a finite amount.
But yeah, it's not. So you're trying to determine whether something can be used more to pay for the rent since he's living at home and not in a facility per se.
I'm just wondering why there's that finite amount. Like, what determines fair rent value, I guess, is my question.
Depending on the area, because commonly it's like any assistance program. You know, if you qualified for housing assistance, it's based on a percentage of what you receive monthly. So I have a feeling in the situation with the special needs home that they determine that each person can contribute so much from their Social Security check monthly to pay for that care, because everything's being done in home, as opposed to the individual living at home with the parents, where they determine that you don't get as much towards that. That's my best guess.
I just want to interject here, Megan. I believe you said Social Security when you meant SSI.
Yes, SSI, sorry.
Yeah. They're not the same thing at all.
Yes.
Okay, it says right here that her son gets $450 a month for food, clothing, and rent. I guess it's a combined figure.
And there's some other things that are involved with the decision of how much assistance you get from your individual county. Some people are in a waiver program where they get a whole host of benefits paid for by their county that has to do a yearly evaluation, where this is completely separate from SSI. It's like a waiver exemption program where they cover sometimes like an adult daycare, schooling, different programs. So there's certain things that are different between the two, and that's getting into more technical matters of what all the benefits are that you qualify for. I was just trying to keep it SSI for now, but there's also waiver programs as well that provide for supplemental benefits sometimes.
So maybe to clarify, we've been talking about SSI and Social Security came up as well. So let's clarify something here. Medicare and Social Security are things you earn by virtue of the fact that you worked or your parent worked. Medicaid and SSI are government support programs that are needs-based. So when we talk about a special needs trust, we're specifically talking about Medicaid and SSI. as a way to shelter assets such that they're not counted against the special needs person for purposes of determining their financial need. We want to maximize their financial needs so we can maximize their Medicaid and SSI benefits. Those things have nothing to do with Medicare or SSDI, which is Social Security disability income, or Social Security itself. Those are earnings-based benefits.
And also, I will interject here, we are not covering those in this webinar, but we do have, coming up, we do have some information on the SSDI and also Medicare and also Social Security. So if you look on our YouTube channel and upcoming webinars, we will be covering those topics.
Yeah, I think you kind of touched base on this with your last answer, Bob, but it says, can you explain the difference between SSI and Social Security?
Yeah, again, Social Security is based on your earnings record or the earnings record of your parent potentially, or spouse potentially. SSI is supplemental security income, is an income program designed for those folks that are found to be financially needy enough to need that kind of support.
Does the $2,000 resource limit also include assets like a car or a house?
Certain assets are excluded. You can own a house and you can own a car, and you can have a $1,500 of cash value life insurance. It's a pretty short list. But like I said, the problem for most individuals that I see is being able to own a home is nice, but how do you afford to own the home? Who pays the real estate taxes? Who pays for maintenance? Who pays the mortgage if there is one?
And with that, that's why the special needs trust is, we did bring up before, you can put real estate into it, but you then need to have a vehicle, and by vehicle, I mean money, to pay for all those additional expenses. So, and I did see something pop up about burial expenses, and that also is included in Pennsylvania as well.
Yeah, another question just popped up was, do assets include a cemetery plot in Florida?
Not sure about Florida. Unfortunately, they're a different animal. They do include them in Pennsylvania, though. Yes, you can set up what's called an irrevocable burial trust for a disabled individual. So.
What happens to the trust when the special needs child passes away?
So that would be built into the trust language itself, that you can control the distribution. So if you have other children you want it to go to, you can have it go back to your other family members. If you have, you can give it to charitable organizations. Maybe there was a specific group or organization that took care of your special needs child, and you want to give money back to them upon their passing. So you get to dictate the terms in a third-party trust of where the money goes when it's left over.
Okay, and what trust have the payback again?
That would be your first party, or sometimes called a self-settled, meaning that those are funds the disabled individual either inherited or received from a medical malpractice lawsuit or an personal injury settlement, or pooled trusts as well. Those have the medical provision paybacks because of the type of trust they are.
How often do you update the trust?
I tell everybody it's kind of like your spring cleaning. You should check your documents every year to make sure if there is a change in your personal family. So if somebody passes away, there's a birth, any major financial change in your circumstances is a good time to review. And then as your special needs child or anybody else ages, once they go from minors to adults, that's a good time to review it. So basically, life changes are a good time to review your documents.
I would also add that it's not just the trust document, it's all your beneficiary designations, right? So if you have a 401k plan or an IRA, it's got a named beneficiary. You want to make sure that the beneficiaries that you name there or in your life insurance policies or otherwise, or any transfer on death type accounts you may have at the bank or a brokerage firm, that all those beneficiary designations line up with the overall plan, because this will be all for no good if you have this fancy trust document, but you forgot to change the beneficiary and contingent beneficiary in your IRA, and that special needs child winds up inheriting something directly. So it's really important that you go through, and a good planner will go through that process with you to make sure your beneficiary designations all, are in lockstep with the overall plan.
Yeah, obviously, if you don't, then you're going to unintentionally disqualify them.
Exactly. The other thing we tell people is it's not just your will and your trust that you want to be attentive to, but grandparents in particular. Great Aunt Maud, thinking she's doing right by her nephew or niece, leaves money in her will to your child, and now they've completely undone all the hard work you did to make sure that you protected that child's benefits. So you need to reach out to other family members that might be inclined to benefit your child to let them know how to do it, the right way to do it.
How long does it take typically to have a trust put in together for a child?
I'll say this, it depends on the client. I say some people can meet with the special needs planner and attorney and be done as soon as possible. Some people it takes months or a year. It just depends on the individual you're working with, it's time frame. There's the initial consultation, then there's the, follow-up and making sure they have the documents all drafted. So it can be a time-consuming process, and it also depends on the individual family's decision-making ability, because there are a lot of decisions to make in the documents. So, it could take a month, it could take a few months, just depends on the individuals.
The actual paperwork.
Megan, you're cutting out there. You said it could take a month and then up to what?
It could take a couple months depending on
her
the individual.
audio cut out. Bob?
The actual paperwork doesn't take all that long. It's the decision making by the key players, right? The thing we like to do, we hand out these little wooden things we call wooden nickels or round to-its, right? You've got to get around to it. You got to get around to deciding that it's time to do the planning, that, choosing a trustee, choosing who you want to be a guardian, if a guardian's to be appointed, and just getting it done. That's Megan runs into the same issue as I do on this. It's parents having to deal with all the other alligators in the swamp, and this is one more thing they have to get to. Once they make decisions about these various things, the process itself is really not that time consuming.
Well, I think that's all the time we have for questions. I want to, let me put up my screen here. On behalf of Advice Chaser, I want to thank our panelists today, the organizations that have worked with us to bring you this webinar today. Thank you so much for attending. Look for an email soon with a link to the replay of this event, and you're welcome to share that replay with your friends or family. Here at Advice Chaser, we're all about helping you find a financial advisor who's a great fit for your life and your financial questions. And our matching service is free to you. Every one of our advisor partners has committed to offer a free initial consultation to anyone we introduce them to. Find out more by going to advicechaser.com and clicking on the link to find an advisor. Once again, from Advice Chaser, thank you so much for coming, and we will see you at another webinar soon. Goodbye, everyone.
Thank you.
Bye now. Thank you.